We have a quorum. I call the meeting to order. This is a panel on security, panel on constitutional affairs, and panel on administration of justice and legal services. Item number 1 is election of chairman. I myself and 2 other chairmen have agreed that I myself and Mr. Horace Cheung will chair the meeting today. Let's see if members would like to elect a different chairman. Otherwise, we will start. I will start. The second half of the meeting will be chaired by Mr. Horace Cheung. In a moment, I will ask members to press the button. Wait till I make the announcement. To be fair, each member will have 3 minutes, question and answer included. The Secretariat suggested that since it is an important meeting, there will be a verbatim record in the minutes. Item number 2, the law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region. All members are invited to participate in the discussion. I'll first ask government officials to speak before I open the floor for members to ask questions. Those who would like to ask questions, I count to 3, press the button. 1, 2, 3. Altogether, 43 members indicated they'd like to speak. In order to save time, I'm not going to read out their names. I'll first read the names of the first 4. The others' name will be shown on the screen. We have Mr. Yu Siwei, Mr. Pun Siu Ping, Mr. Michael Tian, and Mr. Ray Chan. I'm going to dispense with the introduction of officials attending the meeting. Who is going to take us the paper? Secretary for Justice? Yes. Please be quiet. Secretary, please. Thank you. On the 28th of May, the NPCSC passed the decision of the NPC on establishing and improving the legal system and enforcement mechanism for the Hong Kong SAR to safeguard national security. The 6th article talks about the formulation of laws in relation to the establishment and improvement of the systems and mechanisms. The NPCSC was entrusted to formulate the laws. On the 30th of June, it was passed unanimously. Under Article 18 of the Basic Law, and after consultation with the Hong Kong SAR government, the National Security Law was listed in Annex 3 to the Basic Law for the Hong Kong SAR to promulgate and implement. It came into effect on the same day. I'll try to answer questions as far as possible after my presentation. As I said, that the National Security Law on Hong Kong is a unique piece of legislation. It covers 3 areas, that is constitution, structural, statute law, as well as procedural law. The other reason for its uniqueness is that this piece of legislation may be a national law passed by the NPCSC. It has taken into account the differences of legal systems on the mainland and in Hong Kong. A lot of the provisions are catered for the differences in the 2 legal systems. There is a shared purpose. It is for the national security law to be implemented effectively in Hong Kong. The most important part is the general principles. It clearly sets out the purpose of the legislation and basic principles. It is conducive to the understanding and the application of the provisions. Article 1 reads that the law is enacted to ensure the resolute, full and faithful implementation of the policy of one country, 2 systems, to safeguard national security, to prevent, suppress, and impose punishment for the offenses of secession, subversion, organization, and perpetration of terrorist activities in collusion with a foreign country or with external elements to endanger national security, to maintain prosperity and stability of the Hong Kong SAR, and to protect the lawful rights and interests of the residents in the Hong Kong SAR. The purpose is in line with the purpose of the MPCSC for formulating the law. Article 2 sets out the provisions in Articles 1 and 12 of the Basic Law, stating that they are the fundamental provisions for the Hong Kong SAR. No institutions, organization, or individual in the region shall contravene these provisions, namely Articles 1 and 12, in exercising their rights and freedoms. I believe that you're all familiar with the Articles 1 and 12. It says that the Hong Kong SAR is an inalienable part of the People's Republic China. We enjoy a high degree of autonomy. We are directly under the governance of the CPG. Article 3 reads that the Central People's Government, CPG, has an overarching responsibility for national security affairs relating to the Hong Kong SAR. This shows that national security is a matter under the purview of the CPG. It also says that the Hong Kong SAR has the constitutional duty to safeguard national security and shall perform the duty accordingly. Basic Law Article 6 says that protecting the integrity of the sovereignty, integrity, unification, and sovereignty is the common responsibility of all people in China. Articles 4 and 5 says that human rights should be respected and protected. The rights and freedoms set down in the Basic Law as well as the two international conventions should be protected. The principle of rule of law shall be adhered to, namely that a person is presumed innocent until convicted, the right to defend themselves, double jeopardy, as well as other rights. Article 39 reads that this law is no retroactive. Chapter 2 is about the structure. It sets out the composition and duties of the Committee for Safeguarding National Security. It talks about the specialized department under the police force as well as the specialized division under the Department of Justice. There is a specialized division for prosecution. It has already been established. I have already obtained consent of the office, the Committee of for Safeguarding National Security for the appointment of key personnel. Chapter 3 is in relation to the offenses as well as penalties. In the past few days, some public figures as well as the media asked a number of questions. They have taken out words and phrases out of context to ask if these constitute offenses. The elements of an offense has already been set out clearly in the various articles. For the 4 categories of offenses, there is a need to prove mens rea. It has to be proved before the person is convicted. Whether someone has broken the law, all the circumstances will have to be taken into account as a whole. When the Department of Justice makes the decision to prosecute, they act independently and free from interference in accordance with the code. Chapter 4 is the procedural law. It sets out the jurisdiction, the enforcement power of the police as well as judicial procedure. I'd like to point out 2 things. First, the majority of offenses, that is those apart from those save and except those under Article 55, fall under the jurisdiction of the Hong Kong SAR. And we follow existing judicial procedures. In some special circumstances, there are different regulations set down, but they have taken into account the special characteristics of acts endangering national security. These are set for this purpose. In relation to enforcement power, the committee, together with the Chief Executive, has formulated the implementation rules for Article 43. The Secretary for Justice will give you the details. Chapter 5 is in relation to the Office for Safeguarding National Security of the CPG in the Hong Kong SAR. It says that they have the fundamental duty to establish this office. It says that in the 3 special circumstances, the office will exercise jurisdiction. These 3 circumstances is beyond the jurisdiction of the Hong Kong SAR. The office will have to take up jurisdiction so as to prevent the Hong Kong SAR from entering a state of emergency as stated in Article 14(4) of the Basic Law. If you read the preamble of the Basic Law, you fully understand that the purpose of the national security law is to maintain Hong Kong's long-term prosperity and stability. It is also to maintain the territorial integrity, sovereignty, as well as to maintain stability. Secretary for Justice, would you like to speak? I'd like to talk about the details.
Yesterday, the Committee for Safeguarding National Security of the Hong Kong Special Administrative Region held the first meeting, and the Chief Executive, in conjunction with the National Security Committee, exercised the power under Article 43 of the National Security Law to make relevant implementation rules, namely some measures that were gazetted yesterday and came into effect today. There are 7 major measures in the implementation rules. And let me brief members on these 7 measures. 4 of these measures, out of the 7 measures, are in existence in the Hong Kong laws. However, because of new offences provided in the national security law, these measures are now extended to apply to the new offences laid down in the national security law. First measure relates to search of places. Under normal circumstances, a court warrant will be required, but under an emergency circumstances, a police officer not below the rank of an assistant commissioner of police may authorize the search. This is in line with different pieces of legislation already in place, such as Arms and Ammunition Ordinance and also the ICAC Ordinance. That is, under normal circumstances, a court warrant would be required. But in an urgent case, direct search can be performed. Second, about the surrendering of a travel document. Under the ICAC laws at the moment, the authority can require a person to surrender a travel document. So we're extending the power already given under the Prevention of Bribery Ordinance to the national security law and the relevant offences. The third measure relates to property related to offences endangering national security, such that we can freeze the property. We can also impose a restraint order, confiscation order, or charging order. Again, the arrangements are formulated with reference to the existing powers and provisions under the Organised and Serious Crimes Ordinance and the United Nations Anti-Terrorism Measures Ordinance. They are now extended to cover the offences relating to national security law, to cover proceeds arising from an offense endangering national security, and also requiring disclosure of proceeds related to a suspected offense. And this also applies to an offense under the national security law. The fourth measure relates to the request for a person to answer questions and furnish information and produce materials within a certain time frame. These provisions are formulated with reference to the existing powers and provisions under the Organized and Serious Crimes Ordinance and also the UN ATM Ordinance. There are three measures that are new or that are somewhat different from the existing approach. Say, on an internet platform, if a message is published and if the Commissioner of Police has reasonable grounds to suspect that such a message published is likely to constitute an offense endangering national security or is likely to cause the occurrence of an offense endangering national security, then the Commissioner of Police may request the service provider to remove the message. But first of all, the Commissioner of Police should have reasonable grounds to suspect that to be the case before power is exercised. And in exercising this power, the relevant parties are required to remove the message, or else they will face imprisonment or a financial penalty. This applies to the service provider and the individuals related. However, there is also a reasonable excuse in the sense that if the technology is not available for removing the message, then he's free of the offense. And the same defense is given to the service provider. There is also another leg of the reasonable offense. There is a risk of incurring substantial loss or otherwise substantially prejudicing the right of a third party. If the publisher fails to follow the order, police officers may apply for a warrant to seize the electronic device and take action for removing the information. There are also relevant offenses under specific circumstances for the relevant service provider to provide identification record or decryption assistance. The following is a new measure, and that is requiring foreign and political organizations and agents to provide information on activities concerning Hong Kong. In exercising this power, if the Commissioner of Police reasonably believes that it is necessary for the prevention and investigation of an offense endangering national security, the Commissioner of Police may apply with the Secretary for Security for approval for the foreign political organization or the agent to provide information, including personal particulars. And if an organization is involved, the information will also cover activities, assets, income, sources of income, etc. As to what is meant by an agent, it is defined as an organization or an institution in Hong Kong under the direction, instruction, supervision of a foreign political organization or receive funding from such an organization and act on behalf of such a foreign political organization in return for funding or other kinds of assistance. Then the agent will be required to provide information according to the measure, or else there will be penalties, including imprisonment and a fine. These rules are drawn up with reference to the prevailing provisions under the Society's Ordinance. The Society's officers may, in discharging their duties, request a provision of information from societies which the Society's officers think fit in carrying out his duty. So this is not something new. The final measure is in relation to application on authorization for interception of communications and covert surveillance. For less intrusive covert surveillance, a directorate officer of the police force may vet the application. Otherwise, the chief executive would grant the approval. However, we must have regard to the proportionality. And for less intrusive tactics, whether they are available to the police. And only when there is no such an alternative would approval be given. The National Security Committee shall be responsible for supervising the implementation of the measures by the police force. The Chief Executive may appoint an independent person to assist the National Security Committee in performing the supervising responsibility. The Secretary for Security has also issued the operating principles and guidelines for observance by the Hong Kong Police Force. So, Chairman, out of the 7 measures announced, 4 measures are already provided in the existing laws. 3 of them are new or a modification of the existing measures. All of these rules announced are in line with the national security law and the rights and freedoms enshrined in the Basic Law. Ms. Tanya Chen would like to have the speaking notes of the 2 government officials. So can you pass the speaking notes to members for reference? I'll need to write it out first. We have 51 members waiting to speak. In all fairness, each will be given 3 minutes. And please stop when time is up. We start with Mr. Yu Siwing. 3 minutes, questions and answers included. Thank you, Chairman. Since the anti-extradition bill incident in June last year happened, there have been blockage of roads and siege of the airports, causing Hong Kong to become an unsafe city, and arrival figures have dropped by 39%, heavily impacting on various sectors of the economy, including retail and tourism. We welcome the enactment of the national security law in Hong Kong so as to restore calm and stability in society. My first question is this. The national security law is different from the other laws of Hong Kong, and the law enforcement agencies will have to be familiar with the national security law. My question is how the government can provide the proper training so as to better regulate the conduct of law enforcement officers. Under this law, the law enforcement officers will have greater power than other law enforcement agencies. How do we make sure there is no abuse of power relating to national security cases? After passage of the national security law, we have been liaising with the law enforcement agencies and discuss matters relating to law enforcement for better clarity. And we also made the decision not to interfere with the gathering of evidence and investigation. What about internal monitoring? We attach great importance to training. Internally, within the police force, there would be ample training. And we also thank the Department of Justice for providing ample information for the Hong Kong Police Force to draw up guidelines to improve the enforcement mechanism. Now, I must stress that despite the new security law coming into effect, we have powers already in existence among the 7 measures in the existing laws. Basically, police officers are exercising powers already provided in the existing laws. As I mentioned just now, 4 of the 7 measures are existing powers, so we don't need additional training. As for 3 new measures, For example, for CE to grant approval for interception of communications. We have the operating principles and guidelines for the Hong Kong Police Force that is in line with our monitoring effort in the past. On the other hand, I'm sorry, Secretary, time is up. I need to be fair to all members. Next, Mr. Poon Siu Ping. Thank you, Chairman. There are members in this council who claim that the national security law is the end of one country, two systems. I don't agree because it sets out very clearly in the general principles, Chapter 1 of the national security law, that it is to ensure resolute, full and faithful implementation of the policy of one country, two systems and to ensure prosperity and stability of the Hong Kong SAR. Secretary, you mentioned that the first meeting of the National Security Committee was held yesterday. And in relation to the meeting, implementation rules made out under Article 43 of the National Security Law has been promulgated. And there is a concern that police officers can search a place without a court warrant under an urgent situation. Now, Secretary, you just now explained that it relates to, say, arms and ammunition. Can you give us more specific details about urgent situations and also about Chapter 3, Article 4 of the National Security Laws about the offenses relating to colluding with external forces, and that is Part 4 of Chapter 3. There is a concern that even an exchange with a foreign country or organizations would attract this offense. Can you explain that? About urgent situations, when a search of a premises is conducted, in order to avoid the evidence being destroyed, in order to avoid the culprit fleeing, a court warrant may be dispensed with, and this is rather not practicable, in fact, because if a warrant is required, if entry cannot be gained swiftly, evidence may be destroyed. We have, for example, the Prevention of Bribery Ordinance that contains a similar provision. I think this is really understandable. Especially for the national security related offenses, we may have culprits that work at the level of national security. We need to act swiftly. About exchange with other countries, say for the first offense, it says so clearly for secession, there is an intention for the person to separate the Hong Kong SAR from the country. That is, it should be intentional. And about foreign organizations or foreign political organizations or its agents in Hong Kong, say if there is an exchange with this agent or organization, and if the agent or body in Hong Kong carries out activities after receiving funding for or under the direction of such a foreign political organization, and I think we all understand what it means. We have the common responsibility of ensuring national security.
Mr. Michael Tian. Well, there are special powers given to the chief executive under the national security law. Under the existing legislation, if public officers would like to conduct covert surveillance or carry out interception of communications, they will have to get approval from panel judges. But under the national security law, you need an approval from the chief executive instead. I have said publicly that this approach may give the impression that it is a retrogression. When I talk to people in the district, they express the concern mostly about this apart from the establishment of the office. I see that under Article 43, it says that upon approval of of the chief executive, if it is less intrusive, then the chief executive can delegate the power of approval to those no lower than the rank of a deputy commissioner. I'd like to ask you, how do you define what constitutes less intrusive approaches, and who makes the decision? Thirdly, if it is the law enforcement officer that makes the decision, doesn't it give the impression that you're empowering yourself or giving yourself the power to make the decision? Fourth question, is there any kind of review, that is, a similar approach that is in existence in relation to the interception of communications and covert surveillance ordinance? Well, if there is some kind of supervision, will there be regular reports, and will these reports be made public? Secretary for Security. In relation to less intrusive measures, as stated in the implementation rules, this is Tier 2 surveillance. Type 2 surveillance. It means that one using surveillance equipment to conduct this kind of operations in public places, or they cause electronic interference without any approval. We call this less intrusive. But I'm afraid I can't give you operational details because this may have an impact of law enforcement action to be taken by officers in the execution of their duty. But I'd like to say this. The standard, that is, how to strike a balance between protection of human rights and to maintain national security, we have to take into account proportionality and reasonableness. There will be an independent party appointed by the committee to supervise the operation, and that person will report to the National Security Committee. Sorry, your time's up, Mr. Ray Chan. Well, there are 6 chapters and 66 provisions, 666. And it is implemented on the 7th of July, and there are 7 measures under the implementation rules. We should have time to scrutinize this. Dr. Fernando Zheng is rather witty. He has written something that rhymes to ask questions of the Secretary for Justice. The police would arrest anything and anyone. If I have a label that reads Liberate Hong Kong, a revolution of our times, they will be arrested. And if I have something that is innocuous, they may very well arrest me as well. I'd like to ask, how many arrests have they made since this piece of legislation comes into effect? Well, under Article 60, it says that in the execution of the duty, the office is not subject to the laws of Hong Kong. You may say that, well, actually, the office is under the supervision of the CPG and their authorities. But these supervisors are too far away. And I'd like to ask about Article 55. There are some circumstances where the office will exercise jurisdiction. That means people will be arrested and taken to China and tried there. The procedure to be applied will be mainland laws. What about serving a sentence? Will they be served in Hong Kong or on the mainland? Under Chapter 5, you will find information about the role of the office. You will find in Article 45 the mandate. And Article 55 describes the situation when they exercise jurisdiction. When these conditions are met, the jurisdiction will be will be the CPG. So Article 60 talks about this kind of situation when they say that, well, they are not subject to the jurisdiction of the region. But there are other articles stating that the staff of the office, that is under Article 50, that they are under the supervision of central authorities, and that there is also they're also subject to the supervision of Article 3 under the PRC Constitution. So far, how many arrests have there been under the national security law? I think you have to follow up on other occasions. Dr. Kwok Ka-ki. Today, Carrie Lam said that the implementation rules of Article 43 protects human rights. I think it is jarring to the ear. We all know full well that it is a piece of legislation that is unfettered at all. Anyone in the whole universe will be bound by it. Article 22 makes it very clear. Anyone who overthrows or subvert state power will be caught by this piece of legislation. On the mainland, you will have Liu Xiaobo, Wang Chen, Quan Zhang, Xu Ziming, who have been arrested. They have not done anything that harmed the country, and they have only committed one offense. It is a literary inquisition. If you mirror the laws of the mainland, you're telling Hong Kong people that there is literary inquisition here in Hong Kong. If you criticize not just the Hong Kong SAR government, the CPG as well, if anyone is seen as a danger to state power, it's just like on the mainland, anyone can be seen to be a danger of state power, then trumped-up charges can be made. It's just like what happened yesterday in Kwun Tong APM. Some people were arrested simply for holding blank paper. If you ask, the original intent of Hong Kong people is high degree of autonomy, one country, two system, and Hong Kong people governing Hong Kong. Had it not been the extradition bill last year, Hong Kong would not have been plunged into such a devastating state. It's the two of you that are the culprits. I want to ask Teresa Chang and John Lee. Hong Kong now face difficulties that have never seen before. A lot of people want to emigrate. If you think that you are responsible for that, would you apologize to 7 million Hong Kong people? I think that what Dr. Kwok Ka-ki said is worse than swear words. Which word did I say that is worse than swear words? Well, because what you have said is highly misleading. I want a clarification, an elucidation. What have I said? Mr. Lam Chok Ting, point of order. Just now I heard John Lee, the secretary, say that every single word said by Dr. Kwok Ka-ki is worse than profanity. I clearly heard Kwok Ka-ki name the two officials, Teresa Tang and John Zhang. Does it mean that these names are worse than profanity? Well, if anyone is to retract their remarks, both will have to do so. I think we should use our time on the discussion of this item. Don't waste any time. Secretary. What was said was misleading and untrue. Our country legislates for this piece of legislation. It is stated very clearly that human rights will be protected. Applicable laws, say for example, the International Covenant on Civil and Political Rights shall apply to Hong Kong. There is sufficient safeguard of human rights. For the 4 categories of offenses, we are talking about organizing, participating, etc. There is also an ancillary offense, that is inciting. In the illegal occupation of Central, those who have been arrested were arrested for inciting, and they have been convicted. So what was said was misleading. Next, Mr. Jeremy Tam. Article 77 of the Basic Law says that remarks made by legislators in a legislative meeting is not immune. Is that still the case? Well, Article 77 talks about a certain scope. We have to understand the background of this article. It says that legislators shall be immune from legal action. From UK cases, we have seen some cases, yes, if remarks are made and that constitute a criminal offense, the person may still be prosecuted. We have to look at it as a legislative council as an institute. When we consider the privilege, we have to understand that when legislators exercise their rights and rely on the privilege, then they will have to abide by a principle, that is, that they execute their duties. It is not right to say that whatever they do or say, they will be immune from legal action, because it contravenes a basic principle that everyone is equal before the law. It gives the wrong impression to the public. Sorry, I have limited time. First, Article 77 says that members of the Legislative Council shall be immune from legal action in respect of their statements at meetings of the Council. I don't understand why you said that. It seems that you're paving the way for this to be changed after the legislation of the National Security Law. Well, I'm going to move on from this point. Now, I have this blank piece of paper. Have I contravened the National Security Law? May I answer? No, it's my time. Answer my question first. But I haven't answered the previous one. Well, you use your own time to answer. I now hold up a blank piece of paper. Have I broken the national security law? As for J. Article 77. I'm not talking about Article 77. Mr. Jeremy Tam, please don't speak. Oh, give me back my time then, because that's not what I asked. A question was asked. I feel that it's my duty to clarify. Well, so no, I am asking you, have I broken the law by holding up a piece of blank paper? Members, I can change my question. You can't just let her do whatever she wants. She can find the right time to say her piece. Please don't speak from your seat. Let me name you first. Anything to add, Secretary?
Secretary, anything to add? Let me quote from a judgment.
Must not be exercised in a way that would breach the main purpose of Cap 382, that is to maintain secure and dignified environment that Legislative Council needs to conduct its business orderly and effectively. 呢一個就係基本法77條。
This is what Article 77 of the Basic Law is about, and also Cap 3 bracket 8 is about. Can I answer the second question? Sorry, Secretary. Time is up. I need to give the floor to another member. Well, Chairman, is your doing to allow her to continue. Ms. Tanya Chan, your turn. Chairman. One country, two systems has not met its demise. On the 7th of July, on the day when the implementation rules comes into effect, we know that we have the new system, new one system. That is, as long as there is anything that the National Security Committee feels unsafe, it will be a national security issue. And then the National Security Committee will combine the three powers, the executive, the legislature, and the judicial, to be placed under this new body. That is the new system. The other system that originally existed in Hong Kong has gone. We have only one system, and that is the PRC system. If we take a look at the implementation rules and the national security law, the National Security Committee has unfettered power, and it is totally opaque. If we take a look at Article 14 of the National Security Committee, here it reads that the National Security Committee is free from any interference. The work of the committee shall not be information shall not be subject to disclosure, and decisions made by the committee shall not be amenable to judicial review. So the whole system has changed. And then there is another provision relating to the overarching power. According to Article 35 of the National Security Law, a person who is convicted of an offense endangering national security shall be disqualified from public office. But according to Article 79, paragraph 6 of the Basic Law, it provides that if the LegCo member is convicted and sentenced to imprisonment for 1 month or more for a criminal offense committed within or outside the region and is relieved of his or her duties by a motion passed by 2/3 of the members of the LegCo. So which one of the two provisions should apply? Because it happened to myself and Mr. Xiu Ka-chun. Because there was not 2/3 support in this council, I'm still here to put this question to you. Can you explain this to me? Ms. Chen asked a lot of questions. I ask one question, whether this has gone beyond the Basic Law. Well, your question is based on a total misunderstanding of the Basic Law. I'm asking whether this has gone beyond the Basic Law. Next, Mr. Lam Cheuk Ting. She's already answered you. Mr. Lam Cheuk Ting. Tanya, let me help you ask a question. Chairman, my question for Teresa Chang is which one is superior, the Basic Law or National Security Law? National Security Law is enacted on the basis of the NPCSC's decision and the national law. It is a special law, and it should apply to national security related issues. In other words, under the circumstances you mentioned, the national security law shall prevail over the Basic Law. Is that right? The national security law sets out very clearly in Article 2 that the provisions in Articles 1 and 12 of the Basic Law are the fundamental provisions in the Basic Law. The national security law is enacted for the purpose of safeguarding national security, following the procedures in a sovereign state to ensure sovereignty and integrity. In other words, if it involves national security, the national security law shall prevail over the Basic Law. The national security, if an issue relates to the national security, then national security law shall apply. So does it prevail over the Basic Law? Chairman, may I be allowed to answer this question because it's a legal issue? I think time is needed for me to explain it more clearly. The national security law is enacted on the basis of the NPCSC's decision, the Constitution of the PRC, and the Basic Law. It is not a matter of which one prevails over which one. These two are complementary because the national security law is especially enacted. Enactment of law, Chairman. sometimes the two pieces of legislation may be in conflict with each other because of the two enactment organs being different. Which one should prevail? Well, if it involves national security, well, just answer me directly. Is national security law above the basic law? Well, it depends on the issue. Of course, national security. If it is a national security issue, then the national security law applies. In other words, national security law deals with a national security issue. In other words, it is above the basic law, and all rights and freedoms provided in the basic law are no longer wrong. Chairman, may I be allowed some time to explain again? The national security law is enacted in accordance with the NPCSC's decision, which is binding. It adheres certain principles and safeguards rights and freedoms of individuals. Article 4 spells out clearly that human rights shall be respected and protected. In other words, if it reaches Article 4, it doesn't prevail over the other one. Your time is up, Dr. Elizabeth Quat. Please don't practice scaremongering and pull wool over the eyes of the public. Mr. Lam Cheuk Ting, no more nonsense, please. The national security law doesn't prevail over the basic law. It's part of our law. It's just nonsense. It's like comparing the theft ordinance with the basic law. Now, we understand that the national security law is put in place to safeguard the development of one country, two systems. And there must be clout and heft in enforcing the national security law to stop foreign forces from interfering and creating chaos in Hong Kong. This is the public's aspirations, because we just want prosperity and stability in Hong Kong. I have a question for the government. Article 29 about collusion with a foreign country with external elements. It relates to causing hatred towards the government or the PRC government. Now, about the circulating rumors that somebody was beaten to death on the 31st of August in Prince Edward Station, some scholar claimed that this is not in breach of the Article 29. Can you explain whether this is the case? If the answer is in the affirmative, then there is all the more reason to enact another piece of legislation to prevent spreading of rumors on the internet to incite hatred. Let me try to answer members' question in this manner. We cannot decide a case on a single element and say whether it is in breach of Article 29 or any other articles. We need to consider all circumstances and evidence. Well, Article 22 relates to Article 29 relates to requesting a foreign country or institution or conspires to commit a certain offense. And just now, the member mentioned provoking by unlawful means hatred, etc. And there is also another element, directly or indirectly received instructions, control, funding, or other kinds of support from a foreign country or an institution, organization, etc. So we cannot just focus on a single word, hatred. There are other elements to consider. So I cannot give you a definite answer. Chairman, I've also gone through other national security laws in other countries. I understand that they are sprinkled among the different pieces of legislation, such as prevention of fake messages. I want to know whether we should enact something similar in Hong Kong as soon as possible. Secretary, we've heard your view. Mr. Ip Kin Yuen. Chairman, just now when the Secretary answered Mr. Lam Cheuk Ting's question, she said that in terms of national security, then the national security law should apply. I'd like to pick up on this point. say if it's a national security issue, then national security law shall apply. Does it mean that the basic law doesn't apply? The basic law was enacted in 1990 on the basis of Articles 31 and 62 of the Constitution of the People's Republic of China. It is a constitutional document providing legal principles. At different levels, there is a representation that national security should be something at the national level, and as such the NPC can authorize the decision to be made for the national security law to be enacted. The law is enacted especially to target 4 types of acts that endangers national security. There is also a framework drawn up on the legal system and enforcement mechanism. It is not appropriate to compare these 2 pieces of legislation. Chairman. Right. Secretary, I know, Secretary, you're suggesting we must not compare the 2. But then in terms of implementation, we must abide by one set of rules, not both sets. So you say if it is related to national security, then the national security law shall apply. What happens if there is an inconsistency between the national security law and the basic law? Does it mean that in such a circumstance, we should refer to the national security law rather than the basic law? If it involves national security, we should refer to the national security law. In other words, for inconsistencies in the basic law, we should just overlook them. In other words, the basic law no longer provides direction on the overall affairs of Hong Kong as it does before the promulgation of the national security law. No, you're wrong. It's only when the issue involves national security that the national security law prevails. In other words, if it is within the purview of the national security, then we should refer to the national security law but not the basic law. If it involves national security and in presiding over a case, reference will be made to the national security law. But it is not as you intentionally or inadvertently suggest that basic law can be overlooked, because basic law is a constitutional document in Hong Kong. In other words, you can refer to the basic law, but it is no longer useful.
Mr. James To, well, this is very important. Now, the National Security Law 62 reads that if there is any inconsistency between local legislation and the national security law, then the national security law shall prevail. It means that if there is any inconsistency between the national security law and human rights ordinance, then the national security law prevails. It's clearly stated in the basic law. No, Article 62 clearly reads that. You're trying to explain it away? Let's hear the answer first. My question is very simple. Ask all your questions before you wait for an answer. If there is inconsistency between human rights ordinance and the national security law, does it mean that the national security law shall prevail? That's what it says in Article 62. First, there won't be any inconsistency. But it says here, inconsistent. You don't understand what is meant by local laws. BORO, the Bill of Rights Ordinance, is a piece of local legislation. I'm trying to explain to you about what local laws are. But it's very simple, and you're still trying to bend it. Under Basic Law, Article 8, you see that there are those laws previously in force. They are laws that were in existence before 1997. It includes common law. For local laws, they are legislation enacted after 1997. So these laws previously in force, together with the laws enacted after 1997, constitute local laws. If these laws are inconsistent with the national security law, then the national security law shall prevail. Well, amongst the local laws, there is the Bills of Rights Ordinance. That means that the national security law shall prevail over it. Secretary, I've already said it. Let me say it again. Well, it's so stated here. Let me move on to my second question. Basic law says that, well, there are 2 international conventions relating to human rights. They apply to Hong Kong. Which prevails, those international conventions or the national security law? It's not a matter of whether one prevails over the other. There is an important principle in the preamble of the basic law, and it talks about territorial integrity, unity, and prosperity and stability. Article 1 and Article 12 of the Basic Law are fundamental provisions. The national security law is formulated based on these principles by the NPCSC, and it applies to Hong Kong. Secretary, you have the guts to defend this piece of legislation, but you don't have the guts to answer questions frankly. I think that is rather shameful. Let me ask you, in the implementation rules of Article 43, it says that in the investigation of these offences, applications may be made to require certain people to answer questions and supply information. My understanding that failure to do so will attract a criminal liability and maybe imprisonment. For ordinary people, we have the basic human rights to remain silent. It is written in the Basic Law and the BORO. There is also another protection, legal privilege. It's also written in Article 35 of the Basic Law. I want to ask, if I'm required or compelled to answer questions, otherwise I have to go to prison, do I still have the right to remain silent? Am I still entitled to legal privilege? For these human rights safeguards, they will have to be thrown into the bin because the national security law shall prevail. I think the words used by Mr. Ted Hui is insulting, and it is a breach of the rules of procedure. I find the words uttered by Mr. Ted Hui offensive. Look, the chairperson doesn't even realize what you're talking about. I find his remarks offensive and insulting. Well, anyway, I was talking to the Secretary for Justice, not you. Well, the word shameful is offensive. Did you say that? Yes, I did. I said that the Secretary for Justice has been taking us round the block and is shameful. Well, are you going to retract it? No, this is a shameful approach. Who are you talking about? I was referring to the Secretary for Justice, Teresa Deng, that what she did was shameful. I have clarified that is what she did that is shameful. But you have pointed out that you were referring to the Secretary for Justice and you criticized her. I have clarified. I know. That's why I asked you if you're going to retract it. I think that your remark is offensive. I think it is better that you retract it. Is it that under literary inquisition I can't even say the word shameful in a lexical meeting? Well then, I'll let you deal with the point of order. Are you going to withdraw your remark? Ms. Tanya Chen, please wait. I'm talking to Mr. Ted Hui. I clarified that I was referring to what she did as being shameful. Well, you have changed your version again. I clarified. Do you accept? No. What do you want? If you don't retract that remark, I have to ask you to leave. Okay, I will retract it. Let's hear our answer. Ms. Tanya Chan, I don't know if I remember it wrong. Well, I remember that John Lee was referring to another phrase. It was ruled to be offensive in 2004, so it's a different phrase. I just want to remind John Lee, it's a ruling on a different phrase, not this one. Thank you. Yes, indeed, in 2004, there was a different phrase that has been ruled offensive, and Ted Hui did actually say that phrase. There are still a lot of members who are waiting to ask questions. It's a question directed at the Secretary for Justice. Which one? Were you listening? It's about privilege as well as the right to remain silent. I was asking about the right to remain silent and the right to have legal privilege. Under the security law, in Articles 4 and 5, it says very clearly that one is still entitled to all the judicial rights. So, is there any impact on the legal privilege, professional privilege? I think that Mr. Hui is referring to. I was referring to Article 35. Well, are these rights, the right to confidential legal advice, is it affected? I don't understand. Why you're referring to Article 35? It's shameful. You're saying the same remark again.
嗱，剛才咧，我係望住許議員，
I was watching and looking at Mr. Ted Hui. After the Secretary has replied, Mr. Ted Hui was looking at her while uttering that remark. So, Mr. Hui, are you referring to the Secretary for Justice or Mr. Andrew Wen, who's in front of you? There are still a lot of members waiting to ask questions. Please, don't do anything meaningless. Well, I didn't hear. Please continue to chair the meeting. Mr. Ted Hui. Members, please refrain from using offensive remarks. Please don't get bogged down in debates like this. Please exercise restraint. I remind members not to use offensive language. I'm referring to members who are here. Mr. Kenneth Lau. But it is an impartial part of the approach of the country to secure national security. It's been 23 years since the reunification. We still haven't legislated for national security, and we are still being affected by separatists and a number of radicals. 2019 was mired in turmoil. I think the national security law will be conducive to maintaining stability and safety. This will pave the way for long-term stability and prosperity, which in turn will be favorable to doing businesses here. Hong Kong people can go back to their normal lives, and this gives us a chance to start all over again. With the shortage of time, Hong Kong people might not have got a full understanding of the national security law. Well, 99% of law-abiding citizens in Hong Kong do not have to be afraid. I'd like to ask about Article 44. Well, after consulting the Chief Justice as well as the committee, judges will be designated to handle relevant cases. The list of designated judges is not made public. How do you ensure transparency to ensure that parties will get fair trial? Secretary. Well, when we talk about independent judiciary, I always use this. It is to free to decide from Lord Bingham. That is, a decision is made independently based on the facts laid out before the court. This will not in any way affect independent judiciary. Judges will have to take an oath that they have to make a decision based on facts without fear or favor. So when they handle any case, they will have to abide by the same spirit they should when they hear a case. Any measures to ensure the safety of judges? Secretary. If anyone is worried about their personal safety, they may request assistance from the police. Next, Mr. Kenneth Leung.
Article 39 of the National Security Law and also Article 43, subsection 5, both sections got extraterritorial effects, okay? This you have agreed and you have spoken publicly. I would like to know, how are you going to enforce these two articles? If you're not going to enforce it, what are the effects? Are you going to say have a wanted list of people who have committed an offense under the law, and when they come to Hong Kong, you're going to apprehend them? Or are you sending your people to a particular jurisdiction to get these people under our jurisdiction? And what are your plans?
Now, insofar as I think the member was referring to Article 43, did I hear you correct?
To be precise, how about 38? Just concentrate on 38 and answer me, how are you going to enforce the extraterritoriality?
All right. Article 38 is a provision that sets the jurisdiction of the scope of application of this particular law. Insofar as Article 38 is concerned, it deals with foreigners committing certain acts that would violate the national security law that we are looking at here in a foreign place. Insofar as these people are concerned, it is perfectly legitimate for any nation in the world to legislate against such acts.
No, I'm not talking about the rationale for legislation. How are you going to enforce it? How are you going to catch these people? Are you going to send a warrant to the country concerned, or are you setting up a trap in Hong Kong to wait for these people to come to Hong Kong?
Chairman,
not about rationale. How are you going to enforce it? Tell us, please.
Chairman, may I be allowed to finish? And it is very important to understand the concept why Article 38 is unnecessary. It is an international practice when it comes to...
No, I'm talking about, I think it's necessary. How are you going to enforce it? I'm not arguing about the necessity.
I'm grateful for you agreeing the importance and necessity for 38. I will ask the Secretary for Security to answer enforcement.
Chairman, for Article 38, in exercising the power, we have different approaches under different circumstances. Now, in some countries, such as some of the countries that are highly appraised by this member, armed forces may be sent to make an arrest, but in enforcing this law, the Hong Kong SAR will adhere to our own practice. Now, the circumstances vary. First, this person may appear in Hong Kong, and there may also be mutual legal assistance, and anyone breaking the law will be held liable. It's just a matter of when. We will definitely hold those who have broken the law accountable. Mr. Christopher Cheung. Thank you, Chairman. I speak in support of the national security law. It is important in ensuring national security and maintaining prosperity and stability in Hong Kong. As a member representing the financial services industry, I would say that this is good news for the market, because if we have stability, prosperity in Hong Kong, it will definitely be good news. And this is exactly what the national security law brings. After enactment of the national security law, the Hang Seng Index rose by over 1,000 points yesterday. This is solid proof that the national security law provides stability in Hong Kong. I staunchly support the national security law, and I know that investors are discerning. They are not going to put money in an unstable society. The opposition camp claims that the national security law would cause an outflow of capital, and it will also deter investors. They are doing nothing but scaremongering. Now, with the implementation of the national security law in Hong Kong, the opposition camp is suffering a huge blow. They have been resorting to rhetoric such as the one country, two systems being undermined, and people's freedoms and rights being undermined by the national security law. Now, my question is, what publicity effort does the government have to raise the public's awareness of the law and allay their concerns, so as to prevent them from being misled by those with ill intent, especially young people? Will there be special publicity effort made? And what about the details? And there should be timely improvement in the publicity and promotional effort of the national security law to make sure that the effort is fruitful. I will urge the administration not to rely on the conventional methods such as APIs and other traditional channels. There should be other interactive promotional channels to help the public better understand the law, because once they do, they will give great support to the implementation of national security law in Hong Kong. Your time is up, Mr. Jiang. That's just your comment. Is that right? Next, Mr. Dennis Kwok. Chairman, I have a question on designating judges. A few days ago, we learned that one expatriate magistrate is not appointed or not designated as one of the judges or magistrates to handle the offences endangering national security. In paragraph 3 of the statement of the Chief Justice issued on the 2nd of July, it is said that there should not be any differentiation due to the nationality of the judge or the judicial officer. So my question is this. There is no stipulation in the national security law that an expatriate magistrate or judge cannot handle cases concerning offences endangering national security. And yet this is now the case, and this is a very important principle. Despite being called an expatriate magistrate, these judicial officers are actually born and raised in Hong Kong. They have spent their lives, all of their lives in Hong Kong. It's really great insult to say that. And now we have 4 permanent judges, including the Chief Justice at the level of the CFA. And I understand that 2 of them, at least, have foreign passports. But then we need 4 permanent judges to for the CFA to preside over a case. Now, if you take away 2, then the CFA cannot function. Article 44 of the National Security Law provides that there will be certain requirements in designating judges. I don't know the factual basis of Mr. Kwok's allegation. To my understanding, at the moment, we do not have this list of judges or magistrates released. So it's a mere conjecture without a factual basis. So I don't want to comment on that. So can you say in principle whether a foreign judge or magistrate will be designated to preside over national security cases? Well, there is no factual basis. I'm asking in principle whether any foreign judge or magistrate will be designated to handle such cases. Well, there is no factual basis. I ask in principle whether a foreign magistrate or judge will be designated to handle national security cases. Right. Secretary, under the national security law, whether a foreign judge or magistrate can handle national security cases. That's Mr. Kwok's question. Article 44 provides very clearly how it should be done. It doesn't, well, in other words, even for a foreign judge or magistrate, it is not excluded. Well, she didn't answer my question. It's a yes or no question. Let me say once again. Article 44 does not impose any requirement on the nationality of a judge or magistrate. The chief executive shall designate judges and magistrates on the basis of Article 44. Next, Dr. Cheng Chung Tai. Thank you, Chairman. I also have a question about law courts. Say for the Court of Final Appeal in Hong Kong, presiding over a national security case, if at the end of the day the defendant is acquitted, then can the Office of the National Security of the PRC or CPG file an appeal on the basis of Articles 55 and 56? I don't know the basis of your question, but I need to explain. Well, I'm asking about the legal procedures. According to Articles 55 and 56, the Office for Safeguarding National Security of the CPG in the Hong Kong SAR can designate the prosecuting body to prosecute the case, or for the Supreme People's Court to designate the court to adjudicate the case. Now, say when the CFA hands down a judgment in relation to a case, acquitting a defendant in this case, then can the Office for Safeguarding National Security of the Central People's Government in the Hong Kong SAR launch an appeal on the basis of Articles 55 and 56? I think my question is very clear. Because you used the word appeal. How about raise an objection or to prosecute again, for example? Chairman, I'd like to answer his question. Yes, sure. The Court of Final Appeal means the final stage of the legal process. It has final adjudication. There is no further appeal after the CFA's decision has been made. As to whether the office can raise an objection to the CFA's decision, we have judicial independence. So the answer is no. Third point, I try to understand your question on a broader scope, whether the case can be prosecuted again. Article 5 provides that there should not be double jeopardy. It's a legal principle enshrined in Article 5 of the National Security Law. So once the case is the file is open, the case is investigated, and once it goes through the legal process, if the defendant is acquitted, then that will be the end of the matter. So if we follow the legal procedures in Hong Kong, the case comes to a close at the CFA, then if the Office for Safeguarding National Security is not happy with the result, then can the office submit this case to the Supreme People's Court for further handling? I think she already answered your question. You asked about the appeal and re-prosecution. Chairman, yes? I think they should rather explain in writing the highest level of power provided to our to the CFA. Well, I'd like them to explain the highest level of power provided to the CFA. I'd rather answer his question now. The basic law provides clearly that the CFA in Hong Kong should have a final jurisdiction of a case in Hong Kong. When one goes through the legal proceedings in Hong Kong, the CFA has the final adjudication. And once the matter is settled at that level, that will be the end of the matter. There should not be double jeopardy. Yes, I know that, but Article 55 also provides for special cases. I'm asking for these special circumstances. I think Secretary already answered your question, Dr. Helena Wong. I have a question on Article 62 of the National Security Law. It says that this law shall prevail where provisions of the local laws of the Hong Kong SAR are inconsistent with this law. May I ask the Secretary to confirm once again that when it comes to a national security issue, national security law shall prevail over the Basic Law or the Bills of Rights Ordinance, and also the Legislative Council Powers and Privileges Ordinance? This question was asked earlier. Perhaps, Secretary, you can repeat your answer? Yes, please allow me some time to respond to your question. I will go through that point by point. Article 62 refers to local laws. We need to understand the word local laws from the Basic Law. That includes Article 8, the existing laws in the Hong Kong SAR, and also any law enacted by the Hong Kong SAR. So Legislative Powers and Privileges Ordinance and also Bills of Rights Ordinance should be included. I'm asking which one should prevail, the Basic Law or this one? I think this is rather a general question. No, not a general question. It's very important. As the Secretary for Justice, you need to explain clearly, because Article 77 of the Basic Law provides that members of the Legislative of Hong Kong SAR shall be immune from legal action in respect of the statement at meetings of the Council. And Article 78, members of Legislative of Hong Kong SAR shall not be subject to arrest when attending or on their way to a meeting of the Council. I want to know whether these two articles are still in force, or does the national security law trump these two provisions? As I explained just now, Article 77 provides special power to the Legislative Council, or the privilege to the Legislative Council as a whole. Of course, the conduct of members are also protected, but it does not mean that the member will be immune from criminal legal action. What about speech or statements made at the meetings of the Council? Does it come under Article 77, 78? Because it clearly is, you must spell it out very clearly. Otherwise, our discussion here today may also be liable for criminal prosecution in the future. So you need to explain very clearly, Secretary, that we're not immune from legal action whenever we discuss the national security law.
I think that members are very clear about it. Of course, one can discuss about legal points. That's the work of the Legislative Council. But they don't have boundless power. It's not the case that they're immune from any legal action, including those under the national security law. Mr. Jimmy Ng, Well, I noticed that different countries have their national security law to fight terrorist action. I see that under Chapter 3 and Part 3, it talks about terrorist activities as well. There are local legislation against terrorist activities. If the penalty is lighter than that of the national security law, how would you make the decision as to which article or which piece of legislation to use? Under the national security law, there are three types. There is the organized plans, commits, and participates in terrorist activities. That is Article 24. There is also organizes or take charge. The third type is for terrorists as well as these agencies provide training facilities, support, assistance, and there is also someone who advocates terrorism or incites terrorist activities. The current anti-terrorism ordinance does not tackle Articles 24 to 27. I mean, those terrorist activities set down in these articles. When making a decision to prosecute, of course, we consider the evidence. We also consider which offense will more appropriately reflect the culpability. Mr. Eddie Chu, I have two questions. First, if there is a young person in Hong Kong by the name of Liu Xiaobo who has written a 2020 charter asking for the end of one-party rule and to ask for democracy, will his right of freedom of speech be protected under Article 4, or will he be prosecuted under the national security law? Apart from the fear of literary inquisition, we have also seen the details of the implementation details of Article 43. We are afraid that we will not be able to use the internet because, according to the rules, that the Commissioner for Police may require service providers to provide information. Failure to do so would attract an imprisonment and a fine. Facebook, Google, and Telegram have already spoken. They said that they have questions about the stifling of freedom of speech under the national security law. They made it clear that they will not cooperate with the police. Now there is that. What are you going to do? Are you going to force internet service providers to block Telegram, Facebook, Twitter, and WhatsApp, and force Hong Kong people to use Yahoo, WeChat, QQ, and Weibo? I'll answer the first question. When deciding whether to prosecute or not, or whether we can get a conviction, we don't just look at one action. We have to look at the context, the background, the purpose, the aim, and what is intended to be achieved. So we cannot answer in vacuum whether one act constitutes an offense. I think you've just wasted dozen seconds of my time by telling nonsense. Well, what was said was misleading. We only ask for the information to be deleted because it may endanger national security. Well, asking for information to be deleted is something that other countries would do. In New Zealand, they would do that. In Ireland, they would ask for the information to be deleted. In Germany, if it incites hatred and other reasons, they may ask to be deleted. I was asking about Facebook. What are you saying? John Lee, Teresa Zhang. Shut up, John Lee. You sell Hong Kong down the drain. Shut up, John Lee. And Teresa Zhang, I asked you to answer a question, and you have been trying to circumvent the question. I asked you about Facebook and WhatsApp. It's a point of order, Mr. Chow. Well, I think he has made some insulting remarks saying that someone has betrayed Hong Kong. Shut up, Holden Chow. I think you're a scum of scum. That is Holden Chow. If he claims to be a runner-up of such a person in LegCo, no one would dare to claim to be the first. But let me reiterate, Holden Chow, Teresa Zhang, and John Zhang are all scums. And John Lee. Next, Mr. Michael Look. When some members see that their careers are coming to an end, of course, they will say whatever it takes to try to salvage their career. A lot of members want to put the basic law on the opposite side of the national security law, and they have made a lot of vague and wrong assumptions. These are simply wrong propositions. I have not heard anything about conflicting ideas. Well, Article 4 under Chapter 1 clearly states that human rights shall be respected and protected in safeguarding national security, and the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights will apply to Hong Kong to protect our freedoms of speech, of the press, of publication, association, assembly, of procession and of demonstration. The Burn With Us camp would like to fearmonger to scare Hong Kong people. There is another far end of the spectrum that they'd like to engage in. They'd like to narrow down the scope excessively. There is Joanna Chan, who is a professor in the Hong Kong University in the Faculty of Law. And, well, he said that it was just singing songs and chanting slogans. This is, in effect, a literary inquisition. That's what he said. But you do need to look at context. Say, the background, the mens rea. But someone may say in a joking way on an airplane about hijacking the plane. Or I may be talking to my friends and I would jokingly say some threatening words. I think when deciding whether someone engages in terrorist activity or advocates independence of Hong Kong, you will have to take those remarks into context. I think the member is perfectly right. You can't just look at their remarks or their actions in vacuum. You have to look at where they are, why they say those words. They are equally important. Under the national security law, it's clearly stated that the act will have to be proved, the mens rea will have to be proved before we can initiate prosecution to get a conviction. Next, Mr. Alvin Yeung. The real conflict is Article 35 of the national security law. When someone is convicted, instantly the qualification to hold public office is taken away. And under Article 79, then you see that there is a procedure to be followed before you are disqualified. Before the Secretary for Justice answered the last question, they said that, well, if someone has broken the law, where is the checks and balances in relation to the staff of the National Security Office of the CPG in Hong Kong when in the execution of their duty? As I said, that under Article 50, first, they have to abide by national laws as well as the laws in Hong Kong. If there is any contravention, then they would have to be subject to the national supervisory authorities. In the PRC Constitution, under Chapter 3, Article 7, it says that there is a supervisory authority on the mainland, and there are other organs where one can lodge a complaint. Yes, well, Article 7 of the PRC Constitution, there is a supervisory authority. If someone thinks that the staff of the PRC office in Hong Kong has broken the law, where can they approach this supervisory authority, and what is the complaint procedure? I think you will have to refer to the laws on the mainland. You'll be able to find the information online. I think that, well, the Supreme People's Procuratorate is one of such organs. Well, I'm not an expert of the laws of the PRC, so I can't give you the details. But for those who want to seek redress, will have to go to Beijing to go to the Supreme People's Procuratorate, right? Is that right? Well, this is about supervision of the CPG. Well, I was asking about procedure. Does one have to go to Beijing to lodge a petition? Mr. Shikafai, will someone make use of the extradition bill to, and is there movement to oppose to that, to do something illegal? They block roads, they vandalize shops. Hong Kong only see calmness again after the national security law is enacted. We see a lot of fake news and information. Some students and youngsters were misled into taking to the streets. I know that they would have broken the national security law if it had been passed in the past. I know that there is no, this piece of legislation is not retroactive. Well, if they know that they have done wrong and they stop doing what they were doing, would they still be prosecuted?
Secretary, thank you, member, for the question. This national security law does not have a retrospective effect, so I would urge members of the public not to break the law once it is enacted. When a person engages in an act, that the laws in force at the time shall apply. That is, the act engaged in by the person before enactment of the national security law would be subject to the local laws of Hong Kong. Because the national security law is not retroactive, there is no retrospective effect on the act so engaged. But after enactment of the such law-breaking behavior will be dealt with in accordance with the laws of Hong Kong prevailing at the time. So now that national security law has been enacted, we should be law-abiding and not to challenge the law. the law is not retroactive, and I think you need to tell, to hammer home this message to the young people. They might have been misled in the past. Now they are given another opportunity to go home to their family and not to break the law again. This law only targets a small number of people who seeks to separate Hong Kong from our country, whereas for the majority of Hong Kong people, they are protected. We need to explain very clearly to the public and not to repeat this saga of the anti-extradition bill. There are three objectives: prevent, suppress, and imposing punishment on acts endangering national security. And these are our objectives. We want to put prevention first as our ultimate objective. We don't want anyone to break the law. We also want a consensus in society that we should also be law-abiding. Ms. Dari Lee. Chairman, the national security law has become an important part of our legal system and the country's laws. The people in our country are also very much aspired to the implementation of national security law in the Hong Kong SAR. Unfortunately, many people have been resorting to scaremongering and rhetoric, as we've seen before in various incidents, the XRL, anti-extradition bill saga, etc. So I think it is important for the government to explain very clearly this piece of legislation to the people. Like Mr. Peter Shiu said, the law is not retroactive, and we should remind young people not to break the law and not to be misled. And about exaggerations, scaremongering, all sorts of unfounded allegations, demonizing the law, saying that this is the end of one country, two systems, the government should clarify the position as soon as possible to prevent the public from being misled. I want to know whether there is such a mechanism to tackle a large-scale mudslinging and rhetoric, and also for the small number of radicals engaging in acts endangering national security. Instead of invoking this trump card, what else can be done? Now, in terms of the fake messages and unfounded allegations, how will the government tackle these problems so that the public will have a clear idea of what the law is about? Secretary. We will immediately clarify and rebut unfounded allegations and fake news. Apart from disseminating information through traditional channels such as the media, we will also rely on new media such as social media. The Information Services Department will also prepare different information kits, including simplified messages, graphics, infographics, and video clips to explain to the public this piece of legislation. We also attend different platforms, including the Legislative Council, to do briefings. According to the national security law, we are required to take forward promotion and education. I believe the government will follow up on these duties. And I thank members for the comment on providing accurate information. Mr. Ben Chan. Well, it is important for the national security law to have sufficient deterrence. However, on the day of its enactment, the 10 persons were arrested for offenses related to the national security law, and unfortunately, 9 out of 10 were given bail. Abscondment is a common scenario, and I want to know whether courts in Hong Kong will impose more stringent bail conditions for those committing national security offenses to prevent abscondment. Next, like the Secretary said, promotion and publicity will be key in the coming years. However, in the past, we've also heard about teachers in schools distorting the law and disseminating untrue messages, brainwashing the students. So in terms of promotion of national security law in schools, I wonder if there would be a problem when you have proper information and teaching materials, but then the teaching methods are questionable. I want to know whether you have a list so that parents know whether these schools are properly teaching students about the national security law, or whether any teacher in the school are distorting history and distorting the information. Will you set up such a database? Thank you. Well, we understand the importance of teachers in terms of education. I understand that the Education Bureau is in charge of registration of teachers and that they would uphold very stringently rules relating to teachers' conduct and handle complaints of misconduct in an impartial and open manner. And I believe the Education Bureau already explained the same to the public. About disclosure of information, I will relay your suggestion to the Policy Bureau. But let me emphasize that be it in the existing laws or in the national security law, the offense of incitement is not new. Any person inciting another person to commit an offense is an offense. It is provided in the national security law and also outside the national security law, such as the Occupy Central movement. Some defendants were charged with incitement, so there is criminal liability for inciting behavior. What about bail conditions? So very succinctly, bail conditions. The circumstances of each case differs. We need to refer to the evidence and facts of the case, and bail conditions should be imposed in light of the actual circumstances of the case. However, for 9 out of 10 arrestees were given bail instantly. Sorry, time's up. Next, Dr. Fernando Chang. If you want to pick a fight, go elsewhere. You say we should not demonize and exaggerate the national security law. This is not true. What about just chanting a slogan, liberate Hong Kong, revolution of our times? Even this slogan would attract criminal liability. Literary inquisition is coming our way soon. This national security law is so draconian. And there is also the omnipotent provision. Article 60 provides that officers or staff of the Office for Safeguarding National Security shall not be subject to the jurisdiction of the Hong Kong SAR. In the course of performing duty, the staff shall not be subject to inspection, search, or detention. Their vehicles used shall not be subject to the same either. That means we need to work with the office and that they could hold us liable if we get in their way. I don't know how many staff members this office will have, but they seem to be above the law. That means even if somebody got knocked down by their vehicle, somebody got run over by their vehicle, they would still go scot-free. Then who is to enforce the law? Who will take the question? Secretary. Thank you, Chairman. Now we have dealt with similar situations in our existing laws. For example, in the garrison law, it provides that in the course of performing duty, which piece of legislation should apply and what liability will be attracted for certain acts. And there are also privileges, exemptions in existing laws, for example, in relation to staff of the consulate. So according to this article, in the course of performing duty, staff of the Office for Safeguarding National Security enjoys other rights and immunities that are in line with other pieces of legislation. Answer me directly. Who is to enforce the law? As I mentioned just now, for example, in the garrison law, it clearly provides, for example, how the traffic accident involving a PLA's vehicle should be handled. So how? And the case will be dealt with in accordance with the laws. Who enforces the law then? Well, I've already answered your question. I don't know how else I can make you understand my answer. Well, you say it depends on the case. That means you haven't answered me. Well, what about the vehicle running over somebody, killing somebody? Who enforces the law? Mr. Frankie Yik. I think this question is the concern of other members here as well. Article 35 of the National Security Law provides that a person is convicted of an offense endangering national security by a court shall be disqualified from standing office, but there is no time frame specified. And also for Article 39, or the same article provides that the person who is convicted of an offense shall be disqualified from standing as a candidate in the elections. I want to know whether there are similar provisions in the laws of other countries. Secretary? Thank you, Chairman, and thank you, Member, for the question. Article 35 of the National Security Law provides that the person who is convicted of an offense by the court shall be disqualified, and then the Legislative Council Ordinance also has a similar provision relating to subversion. In the United States, as an example, there is also a provision. Somebody being convicted of an offense endangering national security, subversion of state power, for example, will no longer be qualified for enjoying certain rights. So this is not a unique arrangement in Hong Kong. After all, safeguarding national security is important, and endangering national security is a grave offense. So this is not tailor-made for Hong Kong. The next question is this. Article 14 of the National Security Law provides that the decisions made by the committee shall not be amenable to judicial review. Does it include implementation rules formulated in accordance with Article 43 of the National Security Law?
I'd like to, before we let the Secretary answer, extend the meeting by 15 minutes. In relation to the implementation and rules, they are formulated by the Chief Executive with the committee as empowered. So these implementation rules are not amenable to judicial review either. I understand. Some overseas countries, say Australia, the UK, and Canada, announced a travel alert. Canada was the first to suspend the extradition law between Canada and Hong Kong. This has dampened investors' confidence in Hong Kong. There seems to be some kind of misunderstanding. If their nationals don't come to Hong Kong deliberately to do anything that subverts state power, then they don't have to worry, right? Right. They don't have to worry at all, because these are offenses that endanger the national security of the People's Republic of China. Hong Kong still welcome overseas nationals to come to Hong Kong to do business? Next, Mrs. Regina Ip. I wonder who is to answer. Just now, Dr. Zhang, in a rather agitated state, mentioned about Article 60. That is, the acts performed in the course of duty by the Office for Safeguarding National Security of the CPG in the Hong Kong SAR and its staff, in accordance with this law, shall not be subject to the jurisdiction of the Hong Kong SAR. My understanding is that because they are performing acts in accordance with the law, this doesn't contravene the local legislation or the basic law, because before the reunification there were similar laws. And Section 66 in Cap 1 states that there are preserving provisions. Before reunification, it talks about saving of the rights of the Crown. Now is saving of the rights of the state. So this is nothing new. If you perform acts on behalf of the country, there are always exemptions. Secretary, the understanding itself is right. Let me supplement that national security is within the purview of the country. When their staff is performing acts to preserve national security, they are acting on behalf of the state. And that is an important point often forgotten. When the central authorities perform acts to safeguard national security, this is they are acting on behalf of the country. Well, it's just like Article 19. Such acts will not be amenable to judicial review. When we talk about matters under the purview of the PRC, it's like Chapter 5, the duties and roles of the office, they are saving provisions. They will only exercise jurisdiction in very exceptional circumstances. This is like parallel jurisdictions. Well, when the condition is triggered for Article 55 to take over, it will be the CPG or the central authorities that supervise the staff of the office and the office itself. I hope I have supplemented your point. Thank you for your detailed addition. Mr. Charles Mock, who is not here. Ms. Claudia Mo. I have a question about serious undermining of freedom of the press. Under the national security law, in what you call an emergency situation, you can search newspaper agencies, TV stations, and news websites without a warrant, and you can compel them to do what you ask them to. Say I am a reporter. If I'm asked to divulge the source of my information, and I had to, because the penalty will be life imprisonment and the possibility of being sent back to the mainland. Well, when asked the question, the chief executive said that, well, the most important thing is for reporters not to break the law in the first place. But this is not just a red line. It is a red rope tying all over you, and you are just all trussed up. Say there is a UK reporter who is also a columnist, and that person has written a column in a UK broadsheet stating that they absolutely support, say, independence of Tibet. Would you arrest that reporter as soon as they stepped into Hong Kong? Secretary, I strongly oppose to biased and exaggerated statements. I've already explained that there are existing laws that allow searches to be done without a warrant in urgent situations, say for example when the culprit may escape. In normal circumstances, we will apply for a warrant. You can't just single out a profession. This is the spread of prejudiced information. Well, freedom of the press is the last line of defense. We have freedom of the press in Hong Kong, as I've said many times. Whether it's the basic law or the national security law, is stated very clearly we have freedom of the press. I only have one chance. My question has not been answered. Please don't interrupt. I just want to disseminate true information to the public. If it is a professional reporter, of course, one can operate freely in Hong Kong. It's stated clearly under the basic law and is clearly stated equally in the national security law. There is the ICCPR as well as the ICE-SCR. Mr. Roy Kwong, before I ask a question, I'd like to tell you a fable. The wind and the sun are competing as to who has more power. So there is a passerby. The wind kept blowing, but that person refused to let go of his coat. And then the sun started blazing, and then the passerby took off his coat. I think everyone can see the lesson to be learned here. Secretary for Justice, you have the duty to assure Hong Kong people, but Hong Kong people are still very fearful. You have the duty to explain and to answer questions. If when you hold up a piece of blank paper, you might be accused of breaking the law. How have you been doing your job? I don't want to get into a fight with you. I only have 3 minutes. It's said that the office of the CPG in Hong Kong has set up a base in Metro Park Hotel in Causeway Bay. No one knows about it, and someone asked me to ask a question. When will be the official opening of the office? Secretary, you have the duty to explain. If you're invited by the LegCo, would you take that step to explain to us? Now I have given you an example. Well, if the office is going to stage an official opening and ask you to attend, would you be able to attend? I have to clearly explain about the legislative process. This is the duty of the NPCSC in its formulation of laws. Apart from relying on the PRC Constitution, they also have to rely on the legislation law. You may refer to Article 30 and 37. If the purpose of the legislation is widely supported, then they can go through the whole process in just 2 steps or 2 meetings. No, that's not my question. Well, I asked when will be the official opening of the office. If you were invited by the district council to explain, would you go? I don't want Hong Kong people to misunderstand about the national security law and the legislative process conducted by the NPCSC. They have followed the procedure. They have consulted many parties. Well, I give a short reply about the office. I think that the office will make an announcement in an appropriate time. I cannot say for sure. I think the best way is to explain to the public as and when needed. Well, if I have to further expand the meeting, I need consent from members. Last member to ask question is Mr. Charles Mock. I think we'll have to end afterwards. Mr. Mock. Thank you. I'm not going to argue with the Secretary about duty of the work of the legislation by the NPCSC. The announcement of the implementation rule caught us unawares. The press release was made at about 8 o'clock and it came into effect at midnight. There was no consultation. Everyone was kept in the dark. Everything was done by the committee, so it's nothing to do with the NPC or Beijing. It's done in Hong Kong, yet you chose not to consult. I find that regrettable. In relation to the implementation rules, in the past few hours, well, many people say that, the safeguards have been lost and the courts can be circumvented. And there is also information about the handling of electronic messages. We get the strong impression that the Great Firewall of China has been moved to Hong Kong. Companies may want to abide by the law because it's local legislation. They have to, but it's technically impossible. Of course, there are just a reasonable excuses or defense. Well, if they try to do it and then the customers can't actually use the service and they ask for compensation, who is to be held responsible? And it's just so happened that a number of overseas companies said that they would not entertain requests from Hong Kong about requests for information and data. I do think that this warrants concern. I don't want this to become an international issue. From what I've heard from these companies, it simply cannot be done. And the implications are far-reaching. I hope that I would have a bit more time. The National Security Committee formulated the implementation rules because the national security law came into effect on the 30th of June. There are requirements of the Hong Kong SAR to improve the mechanism for effective implementation of the laws. We formulated the rules as soon as possible and made the announcement. That's why we're here to explain. 4 out of the 7 measures are already in existence under current laws. In relation to deletion of information, I've made it clear that we only ask them to delete the information when they may endanger national security. The same approach is adopted in other jurisdictions. And there are limitations as well. That's why it's clearly stated that there are different reasonable excuses. If the technology is cannot be reasonably obtained, and for internet service providers there are also defenses. Say if the technology cannot be reasonably obtained. That's the example cited by Mr. Charles Mock. So we will look and study whether the technology indeed cannot be obtained reasonably, and if substantial losses may be incurred, or if the rights of a third party is infringed. So I explained to you that there are 3 situations under which there is a reasonable excuse.
And I want to emphasize that in relation to these unlawful messages, different countries have measures to require the messages to be removed, including Germany, Singapore, France, Ireland, New Zealand, etc. They have law courts as the gatekeepers. Different countries have different ways of asking for messages to be removed. For example, the government in Singapore can issue a directive for this to be carried out. So you can make reference to the relevant laws, and these are available on the internet. Nothing under AOB. Meetings adjourned. Thank you.